Okay, hi everybody. Good afternoon and welcome to another excellent panel, Economic Liberty and Human Flourishing, Lessons from the Common Law. My name is Maria Monahan and I am an attorney with the U.S. Chamber Litigation Center. I am also a member of the Federalist Society's Federalism and Separation of Powers Practice Group. As you might expect, being from the Chamber, I was very relieved to see that the word and not or was used in today's panel title, but I know that we'll let our esteemed panelists debate whether that's right. It is my pleasure to introduce our moderator, the Honorable Brantley Starr. Judge Starr received his bachelor's degree from Abilene Christian University and his law degree from the University of Texas School of Law. After graduating from law school, Judge Starr clerked for then Justice Don Willett and served as a staff attorney to Justice Eva Guzman on the Texas Supreme Court. Judge Starr also served in a number of roles in the Texas Attorney General's office, including Assistant Attorney General, Assistant Solicitor General, and Deputy Attorney General for Legal Counsel. From 2016 to 2019, Judge Starr served as the Deputy First Assistant Attorney General of Texas, at which point he was appointed by President Trump to be a judge on the District Court for the Northern District of Texas. With that, I'm happy to pass things over to Judge Starr.
Thank you, Ms. Monahan. Okay, so two quick background things. First is everyone knows it's hot, and I will just say, guys, y'all look great. You're starting to not smell great. And so if you want to take off your jackets, put them on the chair, that's totally fine. It was hot in Philadelphia in 1776. They got through it and found good solutions, and we hope to do so today too. But don't let the jacket encumber you from thinking through what's going on. Second, I am a judge on the Northern District. If you noticed from the agenda, Reed O'Connor is a colleague of mine from the Northern District and is moderating our final panel. You may be wondering why two Northern District judges here in one afternoon. And the answer is simple. Reed and I found out on Friday that we can no longer issue universal injunctions. That's freed up a lot of our time. So we could be here doing something productive like this. So thank you, FedTalk, thank you, Freedom of Thought Project, for having us here and letting us engage in a discussion like this. We heard from panel one that when government has lots of power, it tends to behave badly. What of companies? We heard some about that from General Scrimeti in the fireside chat at lunch. The question we should be asking is this age-old debate on what's the relationship between economic regulation and human flourishing? And what exactly is the role of the common law in this analysis? We know there was a good recap from General Scrimeti at lunch on this sort of old guard view of economic regulation, more of a laissez-faire approach, knowing that Adam Smith said there's an invisible hand governing the market and we should let it do so instead of letting the visible hand of economic regulation come in and govern the market. Just because that's been the most commonly held view over the last few decades does not mean it is the only view. For example, Senator Sherman of the Sherman Antitrust Act was a Republican. Calvin Coolidge, hardly the most liberal president ever, was later on to say that the Sherman Act was largely just a recodification of the common law. And then we heard from Senator Lee at a recent FedTalk event that we shouldn't just be afraid of the tyranny of government, we should also be afraid of tyranny of monopolies. Fleshing out this debate is also more important now than ever before. Remember, we got the Sherman Act in the Standard Oil era, and we are now living in the big tech era. So this question on the level of appropriate economic regulation to result in maximum human flourishing is as important now as it ever has been. Let me introduce our panelists who can flesh out this debate with us. And I'll just say that we've agreed to go on a first-name basis, largely because my friend Austin Rogers, I would have to call him Mr. Rogers for the next hour and a half. And I tend to chuckle and laugh when I do things like that. I had a trial last year with an expert who had his PhD, and his last name was Pepper. So every time I called Dr. Pepper to the stand or thanked Dr. Pepper for his testimony, it was hard to keep a straight face. So our panelists, Joseph Coniglio is at the Information Technology and Innovation Foundation. He runs the Schumpeter Project on competition policy. His work encompasses all aspects of antitrust and innovation policy with a focus on digital platforms, monopolization policy, dynamic competition. He's widely regarded as a top antitrust and tech policy expert, having testified before Congress on antitrust and having appeared and been quoted in leading media. He's published numerous articles addressing contemporary issues in antitrust law, competition policy, and political economy. He previously worked at Sidley Austin and Wilson Sonsini. And Keith Hylton is the William Fairfield Warren Professor at Boston University and a Professor of Law at Boston University School of Law. Before he joined BU Law in 1995, he was tenured at Northwestern Law. He's a prolific scholar who is widely recognized for his work across a broad spectrum of topics in law and economics, including tort law, antitrust, labor law, intellectual property, civil procedure, and empirical legal analysis. He's published 4 books and more than 100 articles in numerous law and economics journals, and serves as a contributing editor of the Antitrust Law Journal. He's a former chair of the section on antitrust and economic regulation, and a former chair of the Law and Economics section of the American Association of Law Schools. He's a former director of the American Law and Economics Association, a former secretary of the American Bar Association's Labor and Employment Law section, and a current ALI member. And Austin Rogers, he is chief counsel for the Senate Judiciary Committee, covering the civil portfolio for the chairman. He obtained dual graduate degrees in law and theology from Duke, where he served on the Duke Law Journal and also on the Harvard Journal of Law and Public Policy. After law school, he's clerked for Chief Judge Stephen Merriday in the Middle District of Florida and practiced at White and Case, prior to serving as chief civil counsel for Senate Judiciary.
Section of economic liberty, which I'll define as the idea that the state's not generally going to get involved in determining market outcomes, right, as opposed to, let's say, something like regulation. And then the common law, which, as you all know, is a body of private law focused on providing rules for transactions between individuals to help organize their behavior, in contrast to, let's say, public law, which concerns the relation between the individual and the state. Now, there's lots of ways I think economic liberty and the common law go hand in hand. So it's not just the idea that markets need legal rules, they do. But when you look at the history of U.S. antitrust law, for example, in 2 periods, the courts broadly replaced a public law understanding of antitrust law, protecting democracy, with a private law one, such as the Consumer Welfare Standard. And then at the same time, they also abandoned more interventionist economic paradigms, whether that's sort of the early populism or the structured conduct performance paradigm, and embraced more laissez-faire doctrines, first classical economics and then later neoclassical economics. So second, the relation between the common law and human flourishing, the latter of which I want to define as basically a moral framework that has its roots, let's say, in Aristotle or natural teleology, but which I think you could also say more broadly includes modern understandings of natural right. Think Locke, Hobbes, and Rousseau. And here I think there are 3 ways to sort of understand the relationship. So first, you have neoliberal commentators that basically waved away the meaning of flourishing. They didn't say it was very relevant at all to thinking about law. I won't name names, but you probably have a sense of who those folks are. And then second, you also have people who would say that flourishing and the common law work hand in hand, right? That really the common law is sort of an empirical, tried and tested way to get at ultimate truths of human flourishing and natural law. And then I think there's also another view which says there's a real tension between these 2 concepts, that flourishing, as I say, connotes this idea of natural teleology and the natural law as being the ultimate basis, or at least a key basis for law, whereas with common law, it's obviously precedent, judges that have the primary basis for shaping law. So I think that is somewhat of a tension at a high level. Now, with respect to economic liberty and human flourishing, I think you also have 3 basic perspectives. You know, if you look at neoliberal types, you know, they would basically, again, wave away the idea that flourishing mattered, right? Economics is supposed to be a positive science, right? Not one that is focused on morality or natural law. And then you also have the classical liberal view, right? We mentioned Adam Smith already, but this is the idea that economic liberty and flourishing go hand in hand. You know, think about Smith's lectures in jurisprudence, where the values of capitalism, the values of economic liberty, punctuality, trust, et cetera, are good for society at a moral level. And then also I think there's a third view where flourishing and economic liberty are seen to be in tension, and I think it's something we're certainly going to drill down on. So you have on one level an economic tension. You know, if you think about things like the just price doctrine historically, right, grounded in natural law and an Aristotelian type of ethic, obviously that has some tensions with the idea of economic liberty in a more modern sense. But even aside from the economic tensions, there's also, I think, a moral tension that you see described in thinkers like Schumpeter, who I study very closely, and also Weber, you know, where economically capitalism is great, we have no problem, but there is a sociological effect from capitalism that can be deleterious in the sense of alienating the moral values that make it work, right? For Schumpeter, that's the entrepreneurial spirit. For Weber, the Protestant work ethic and the idea of the iron cage that he talks about. So I think Schumpeter had this right, and I want to use his insights to sort of tie this all together. From an economic perspective, I think we want to say creative destruction is good, and we don't want to get in the way of the economic liberty that I think makes that possible. But creative destruction does, I think, have a chilling effect on values, and we might say the entrepreneurial spirit, which isn't just about self-preservation or natural law or flourishing, but for Schumpeter, I think it goes beyond that. It's really a sense of heroic and creative values, which I've described as actually in a paper it's just released with the George Mason Journal of Law and Public Policy as something almost pre-Socratic in nature, really deeply traditional values. And this is why I think we should see the common law, as Blackstone described it, this idea of the common law as the ancient collection of unwritten maxims and customs, right? These are the rules we need to protect these deep-rooted values, among other things, that I think are essential, as Schumpeter described, to making economic liberty work, precisely because I think they actually go beyond what we might think of as flourishing in natural law. So again, bringing this sort of project to antitrust is something I've tried to do a lot of lately as we have this big debate on the right about what we think about economic liberty and flourishing. And I think you have a couple different groups, right? So on the one hand, you have folks that basically want to double down on the neoliberal ideas. And then you've got a bunch of other folks, I would include myself, who do want to bring back some sense of order, some sense of flourishing, some sense of natural right back into political economy. But even within that group, right, there's a debate about what conception of order we want. Is it Locke? Is it Aristotle? Who knows? And then also this idea about whether we want to keep economic liberty along with this new idea of order that we're bringing into the economy. So again, needless to say, I'm in favor of this ordered liberty approach, as I'd call it, the sort of Schumpeterian paradigm, both for antitrust and even more generally. And I think it really reflects a private common law view that you might say is similar to Justice Holmes, for example. It's very realist, which I think, at least in antitrust, is consistent with how we've seen the law evolve. And, you know, contrary to some of the formalist modes of thinking, like originalism, let's say, where you also see some debates now in the antitrust case, which I just don't think fit antitrust very well. So that's a lot for starters. I think I'll just stop there and turn it over to you, Keith.
Thank you, Joe. There's so many things that we can talk about under this topic that I'll mainly sketch some things that I want to expand on further and try to stop as soon as I can. When I think about the topic lessons from the common law and think about my own background, it would have initially have been a strange topic for me to talk about. I was trained as an economist at MIT, so I came into teaching law, doing a lot of equations. It just happened that in my first job, I had a commute going from Chicago to Evanston, and I had to take a train, and I was on the train for roughly an hour, and so I decided to bring some things to read. One of the first things I brought to read was Blackstone, all 4 volumes, and sat there in the train and read it word for word. And I will say, if you haven't read it, it's a good read. You should go ahead and take a look, because Blackstone was an amateur poet, and so it's much easier to read than most, modern law textbooks. But I really want to get into brass tacks and talk about some things that are concrete before I get through my few minutes here. So regulation versus common law, we see that conflict in a lot of areas. We talked about antitrust already, and that's an important topic. We see the same problem in environmental law, same issues in labor law. And where we see the major deviations from a common law approach, we see through statutes, through statutory regulatory models. We also see it in special courts, special fora for dispute resolution, such as the FTC and many of the administrative agencies, and even, as I've come to learn lately, universities have so many adjudicatory processes that are divorced from common law methods that that's increasingly an area where we have a system of special courts. There's a special quality of the common law that I think is really important and at least helps us understand its success and helps us understand what's unique about American antitrust law as well. because American antitrust law is really based on the common law model. The Sherman Act is a very sparse statute, at least the important parts of it. In fact, you could summarize the Sherman Act in just a few words. Section 1, don't fix prices. Section 2, don't monopolize. That's pretty much it. And then that was kicked to the courts to figure out the details. And they worked out the details through a common law process. And now, what is that process? It's where adversaries go before a judge. And the judge hears both sides, takes into account the interests at stake, and tries to reach some resolution, what seems to be a reasonable answer. In a sense, he's trading off. The judge is trading off the interest and the utilities of the sides, both sides of the dispute. And it so happens that the common law, as a result of this compromise process, often reaches very good decisions. In fact, an economist would say wealth maximizing decisions or utility maximizing decisions through this process of trading off different valuations of the interests at stake. I think that's key to the special quality of the common law. It's a very simple process that it can start with just basic arguments, a norm of what you're trying to do, and then the details all come over time through specific disputes, through resolving specific disputes. It doesn't get ahead of the problems. It doesn't try to predict what the solution should be. It takes a passive approach. The problems come to the judge, and the judge works through them. And at bottom, it is this trading off of utilities on different sides of a dispute in a rational way. Again, I think that's core to American antitrust law, and I think it's why American antitrust law is unique. We don't have that. We don't observe that process in Europe. We don't observe that process in European antitrust law or in anywhere else in the world, where it's largely a statutory process governed by special courts. As a result, I think American antitrust law is much more refined, much more reasonable and intelligent in the answers that it reaches than the antitrust law that's developed in any other part of the world. To that extent, I think it reflects something about the common law process, which we observe in other areas where the common law has been at work. And again, I mentioned two of them already, environmental law. In environmental law, you have a common law of the environment, which is largely nuisance law. Then you have the statutory process, and nuisance law makes rational trade-offs between the interests at stake. I mentioned labor law. Labor law has the interesting feature that the NLRB courts actually proceeded through a common law process themselves for many years. You could say they still do, though there's more politics involved now than in the past. But again, we see the same trade-off between a common law process versus a statutory process and versus a process in which specialized courts reach conclusions that would be inconsistent with a common law process. So let me just mention two examples. I've mentioned American antitrust law as largely successful based on this, what I would describe as a common law approach. On the other hand, the results that come out of specialized courts, I would say, are not as successful. I would mention the FTC process as one, because the FTC has its own court, its own rulemaking process, and the most famous decision coming out of the FTC recently was the total ban on non-competes. Now, the ban on non-competes was very different from anything that would have come out of American antitrust law. In fact, there was no ban on non-competes, non-compete agreements in American antitrust law. And in fact, the common law basis of antitrust, that is the law governing non-competition agreements before the passage of the Sherman Act in 1890, that common law was all based on a rule of reason approach that was trading off the interests at stake and taking a case-by-case approach. So very different from what the FTC did when it announced a ban on non-compete agreements. And I cite that as an example of the distortions and the problems that occur when you get away from the common law process. When you get away from the common law process, then you get rent-seeking legislation, you get specialized courts and rent-seeking processes. I could offer more examples of that, but I guess the argument I'm making is to the extent that we can take these disputes and draw them into a common law-like process, that's actually an improvement. It's a simpler process and one that does a better job in every regulatory sense that we can imagine. I mentioned the universities as another example. The universities have their own specialized processes, adjudicatory processes in courts, in a sense. As a result, there's a lot of regulation that's happening within universities that's completely inconsistent with freedom that we take for granted. And one example, I thought I would just mention this, one example is the treatment of Amy Wax at University of Pennsylvania, which has been in the news recently. Now, the things that Amy Wax has said, I certainly don't agree with. However, the fact that I disagree with her is one of the reasons I would defend her freedom of speech. And I think that what Penn has done, which is to strip her of her title, to, in a sense, come close to firing her without really firing her, goes beyond what any university should do when there's a disagreement with the speech of a professor. I think the right approach for the university would be to speak against, if it wants to, but not to, in effect, terminate the professor for speech with which the university disagrees. In fact, I'm somewhat alarmed by that case because it strikes me as, a very bad mistreatment in the face of a new administration that actually takes these issues into account and seems inconsistent with the due process approach that we see reflected in recent Supreme Court decisions such as Harvard versus SFFA. We can say more about that. I mean, I can tell you the university special court process has got enormous problems. In fact, I can tell you that it's in some ways almost a revision of the French terror courts, and that's not too extreme to say because there's some really strange things that are happening within the universities. I can give you an example involving myself, which is one of the reasons I paid close attention to the Amy Wax case. I am the only professor at my law school who has written a textbook for first-year classes. I wrote a textbook on tort law. In fact, I think I may be the only professor who's written a textbook for any law class. I've written a couple of textbooks for law classes. And right now, I am barred from teaching the first year because I use Socratic method in a way that an administrator felt was harmful to the interests of women and minority students in my class. So this gives you an example of what's happening right now in universities. I mean, we have some administrative processes that are completely inconsistent with anything that you would see in courts. And again, I think this is an example of a deviation from the approach that we see in courts and under the common law process. And just one of the examples, in fact, obviously it deals with me, so it's easy for me to, to have strong feelings about it. But I want to get back to my general point that when we move away from this common law process and get into statutory regimes, special courts, we're moving into systems in which rent-seeking motives, targeted abusive approaches become very easy for people to conduct within those processes. I'll stop here.
Keith, I know you like asking questions, and I'll just say that because you can't anymore, we have openings for federal judgeships in Texas. So Reed O'Connor and I have one in Dallas. So if you want to ask questions, we've not yet been told we cannot ask questions. We just can't issue universal injunctions. Okay. So keep that in mind. Okay, Austin, you still awake? Bad check?
Still
you still
awake.
doing all
Good
right?
to go. Yeah. Can everyone hear me? Great. So thank you to the Federalist Society for putting on this panel. Very honored to be here with you gentlemen. So I jumped on a call with these two guys a few days ago, and we were doing sort of a run of show. and I thought to myself, they both speak extemporaneously better than I write, so I should probably keep my remarks based on my own experience and not on the more theoretical sort of philosophical framework. So I just want to offer a few brief observations from my time on the Hill. And so first I will start with a story that I hope will sort of shed light on some of the definitions that we'll be discussing today. So whenever I was in college, I took a microfinance class, and we went to El Salvador for this field study. And this is a pre-Bukele El Salvador, so think before his interview with Tucker Carlson, country kind of destitute and disarray, and very much so, riddled with gangs, so on and so forth. And we stopped off in like a village one day, and these sweet Salvadorian ladies are teaching me how to make pupusas, and I remember kind of thinking to myself, I'm like in this dingy hut, and I remember thinking to myself, these women are more joyful and more socially connected than anyone I've seen in the U.S. and in the West. And I think, a lot of people here, if you've ever been on a mission trip, if you've ever kind of been to a developing country, that's the experience that a lot of people have. And so, I think certainly economic liberty contributes to human flourishing, but I don't think it's sort of a one-to-one kind of thing where you have more of one and you get more of the other. So first observation. Second observation would be, touching on the common law. As especially Joseph sort of pointed out, I think there is a little bit of a rift going on amongst conservatives right now. So, there are plenty of conservatives that want to kind of revive or repristinate the Lochner era and want to treat economic liberty as some sort of fundamental right. And they might ground that in the Privileges or Immunities Clause. They might ground it in other places. But in any event, they want to sort of rein in big government, allow people to contract freely, want a very free sort of laissez-faire market. But, as Mark Metter recently pointed out in his piece, Antitrust Policy for the Conservative, which is a very good piece, I think published like, I don't know, Joseph could tell us, but like a month and a half ago, yeah.
May, yeah.
He basically says, like, if we buy into the myth that we should only be worried about big government, we're going to be trading one form of tyranny for another, because big business, economic power can be just as formidable, can be just as potent as big government. And so I think he's really spot on with that observation, and that the fact that big business can be just as harmful to human flourishing. So, something I've seen in this vein throughout my work and my time on the Hill, and I'm going to engage a little audience participation. What's your name? Philip. You have a favorite sports team? Well, who is it? Okay. Spanish United? Manchester United. Okay. As an Arsenal fan, I have to question your judgment, but it's all good. Sports betting is an issue that has come up on the Hill a lot. There are bills that pertain to it. There are hearings that pertain to it. And plenty of lobbyists that come to the Hill and talk to us, or plenty of companies that come to the Hill and talk to us. And what I can tell you about a lot of these bet sporting platforms is that they know Philip, and they know, let's suppose you're a sports bettor. Don't want to like cast any aspersions, but they know how old you are. They know that after work on Thursdays, you might like to come home and have a couple cocktails. They know that after doing so, you might place a $50 prop bet on Manchester United, and that although it doesn't exactly work for the metaphor because you'd be watching on like Saturday morning or something, but you get the point. They collect so much data on us that they can actually target Philip, and they can push targeted advertisings to him to make him bet more. And that's the case whether or not Philip has a gambling addiction, whether or not it's harming his marriage. I don't even know if you're married, but or whether or not he's bleeding his savings account. So 50 years ago, this sort of laissez-faire libertarian vision of economics, I think, might have worked out well. But I think this day and age with big data, with big tech, in sort of our digital era, I think sort of the vision that Metter puts forward is a little more useful. And so, let's see. In either case, like I think we would all recognize here, I would hope on the panel, that Philip, even if he has engaged in a free contract, if he's read all the terms and conditions, agreed to them, if you have two participants in the market entering freely into a contract, this isn't a great vision of economic liberty. It's not a great vision of human flourishing. So there's probably something remiss with the sort of, I don't want to say Borkian because it's, I think a little bit unnuanced, but with this sort of like libertarian approach to economic liberty. So, in either case, whenever companies, large tech companies, large companies in general are acting in harmful ways, I think there needs to be something that sort of addresses in response to that, and I think the common law can be a pretty potent, but frankly incomplete way to address it. So, I would say in terms of the common law, it's pretty good at reining in private power, especially in the area of antitrust, but it's not perfect. So I think there are examples where it goes too far. So I'm thinking, Aspen skiing and, refusal to deal jurisprudence. I don't know if y'all are familiar with that case, but, in my mind, that's a bridge too far for antitrust jurisprudence. But then sometimes it doesn't go far enough. So if a company, for example, or a news outlet throttles the Hunter Biden laptop story, which is sort of material information for a voter, there might not be any recourse or remedy. So, I think in that sense, the common law is incomplete in addressing the concerns that we might have to rein in private power. And so, so if the common law is insufficient, we might think legislation or Congress is sort of a different approach, regulation. But even in that vein, I've found that that's also insufficient. So anytime we try to do anything on the Hill, even implement the most modest reforms, big tech will swarm the Hill with lobbyists, and they will have all sorts of red herrings about how you're going to break the internet if you do this, so on and so forth, and honestly will use scare tactics to kill legislation. And that's the case for kind of like really any big business that you can imagine. And so, legislation is hard to do, especially with the bloated administrative state. Congress hasn't really been exercising its legislative muscles. And there's also a pesky thing, the Constitution, which kind of limits a lot of what Congress can do. So if we're worried about censorship, for example, from big tech platforms, having worked on legislation in that vein, I can say it's really hard to come up with legislation addressing censorship without running afoul of the First Amendment. So I would say common law incomplete, legislation incomplete. And so, is there an area that can sort of buttress that or that can address some of the other issues that we have if both of those are incomplete? I would say one promising area that I've seen as of late is law enforcement, and it's antitrust enforcement in particular. And, this is a little bit of a controversial topic right now amongst Republicans, amongst conservatives, because for decades it was dominated by a Borkian sort of approach to antitrust, and very much so not going to restrict consolidation, very pro-merger, et cetera. And now, as seen through the Trump administration and people that he's sort of put at the helm of major agencies, there's a very much so more pro-enforcement approach to antitrust law. And so, Gail Slater's at the helm of the antitrust division. Andrew Ferguson is heading up the FTC, and both of them have expressed very sort of pro-enforcement sensibilities. And even in nominating them, Trump said, you know, we need to rein in big tech. So, you know, I think that might be a promising area. Roger Alford called this sort of Kool-Aid of antitrust economic populism last Congress when we had him as a witness for a hearing, and I think that's sort of an apt term for it. For me, it's not necessarily always the most cogent or internally coherent paradigm or set of principles, but I do think in terms of the you know, goods it gives us, in terms of what it contributes to human flourishing, it shows a lot of promise. So to summarize, I think if by economic liberty we mean purely sort of laissez-faire libertarian economics, I think we sort of missed the mark. C.E.G. Philip, no offense, Philip. And then if by human flourishing we mean the community that I experienced in El Salvador, I actually also think that's incomplete. I think we need some basic goods to be able to provide for ourselves and for our families. If heaven forbid something happened to one of these ladies in El Salvador and they got sick, like, would they have access to adequate medical services? Were they literate? There were all sorts of ways in which that narrative is also incomplete. And then I also think the common law is incomplete for addressing a lot of the social ills that is wrought by big businesses these days. And so, you know, kind of drawing it to a close, I'd say, you know, need to provide for ourselves, our families. We need our daily bread. Certainly that contributes to human flourishing. But I don't know that the common law in itself is sufficient to deliver that daily bread. And I am hopeful that economic populism can sort of buttress that and help toward that end.
Thank you, Austin. I'll note that we got our first grievance filed against the panel for your use of the Socratic method, but I will summarily overrule that. Joseph, you didn't get a chance to talk through and respond to your co-panelists, so I'll give you that chance, and same with you, Keith, and then we'll move on to some questions.
Sure. No, thank you. So I think the first thing I would say in reference to the Mador speech, I actually think it provides a good case study to respond to both Keith and Austin. So I agree with Keith's framing. I think in general the common law is in opposition to regulation. The two usually don't find themselves on the same side. But actually Commissioner Mador's speech is an example of maybe an exception to that, because at least nominally, I think Mark does want to maintain a consumer welfare standard, right? He doesn't want to jettison that idea, but it's clear he doesn't believe in anything like laissez-faire. I mean, he basically frames this in the idea that we don't want to care too much about false positives anymore. We want to focus more on false negatives, and that's just not consistent with sort of a general market approach. So that's, I think, point number one. Point number two, I agree with the diagnosis regarding censorship and the antitrust issues that are there. And I would just add, a lot of that does have to do with refusals to deal. And why it's so hard to bring that kind of a claim. So you know, the issues are basically, you know, if a platform refuses to deal with certain content, that would be, if anything, an exploitation of market power, just like high prices would be an exploitation of market power. But that use of exploiting market power you may have is not an antitrust violation. You need to have some sort of exclusionary or collusion to make it violate the antitrust laws. And the problem with the censorship cases from an antitrust perspective in this regard is usually, I mean, it's hard to think of a case where it would be found, but a platform doesn't compete with the content they're taking down, right? There's no exclusion there that the antitrust laws would be worried about. And on the collusion claim, at least I haven't seen any evidence that, you know, the different platforms themselves are colluding with each other to determine where which content should go down. So those are the issues with an antitrust claim. Now, there is, I think, some interesting questions about these third parties, and you're seeing that start to develop in certain areas, right? If you have a third party that's, let's say, organizing a bunch of advertisers to refuse to deal, or working with the platforms to tell them what content to take down, that gets into what we call hub and spoke territory, where you have a third party group organizing collusion. But the problem with this, and it gets into what Austin mentioned, is now, these sorts of groups typically have some non-commercial political purpose that is motivating their actions. And that's where you get real strong First Amendment protections under the applicable precedents like Claiborne and things like that. So what you're actually starting to hear from some is using more consumer protection tools like the FTC's Unfairness Authority to try and deal with censorship concerns, because I think there's an understanding that the antitrust laws are not the right way to do that, even if the common law is not. So, there's a lot more to say on all of this stuff. Why don't I just stop there?
Fair enough. Okay, Keith, any comments on your co-panelist comments?
Sure, I'll make it quick. So I think that I don't want to say that there is this dichotomy between between common law and regulation, because common law is a form of regulation. I just think it's proven to be one of the best, if not the best form of regulation that we can find, because of its flexibility, its ability to take into account specific information, its relative imperviousness to rent-seeking groups coming in and getting things just to go their way. I think these are important features, and of course, the common law process has had a lot of time to develop, to make patches to itself, to develop rules on the presentation of evidence and burdens of proof that make sense and have improved the process over time. And then if you look specifically into antitrust law, which I say has developed through a common law process, and this country is unique in that sense, that antitrust law has developed in that process only in the U.S. What you see is that antitrust law is flexible. It's open to considering all sorts of different arguments. There's no sense in which the antitrust laws have to be reformed to take into account new technology, because the laws are already flexible and already open to take into account a lot of different factors. So the law can change with technology and change with tastes, with preferences in technology over time. And in fact, if you look at the history of antitrust law, what you see is that antitrust law, the doctrine, has made its own self-corrections at many points. It's reached stages where the courts, judges have looked at the law and said, we've kind of reached a point where this is ridiculous, and we need to overturn this rule and go to something different. And that's happened in a number of times in the Supreme Court's history of antitrust doctrine. So those are important features which you don't see in the regulatory process. Again, the problem with and when I say regulatory process, I mean the sort of statutory regulatory process that's divorced from the common law process. And then I've also referred to sort of the special courts, in-house special courts that we see in various places, like the agencies, and I refer to the universities as having developed their own elaborate special courts in many ways. And there we see some troubling deviations from many of the superior features that we see in the common law. And so for those reasons, I say that the common law is sort of a better mechanism for human flourishing, for the enhancement of, let's say, economic wealth or social welfare than other processes that we see out there.
Well, what I would ask on a first question is, our audience may be as well versed in antitrust as the three of you are. But if they're like me, I found out in the last couple of weeks that we didn't expect any new guidance from the Trump 2 administration on mergers. All right, and I guess I've just gotten accustomed to seeing new administration, new guidelines. And I expected that to carry over. We haven't. And that's with the departure of Lena Khan, right? So many of us might have expected new guidelines. We've touched a little bit on some of Ferguson's statements on big tech censorship. We touched a little bit on Mark Metter's white paper from May on we still have a conservative case for robust enforcement. Can we dwell a little bit more on what we expect to see from this administration, and also piggybacking on the notion you brought up, Joseph, on consumer welfare? Are we seeing there's a new concept that consumer welfare is not accounting for, that the new guard is thinking of, like thinking of protecting small businesses? Or is it simply a new, perhaps more refined way of thinking through consumer welfare than we've seen over the past couple of decades? I don't know if you want to take a first shot at that, Joe or Keith or Austin. It's for anyone.
Yeah, I'm happy to jump in here. So, at least with respect to the merger guidelines, I was a little bit surprised that the new HSR rules weren't overturned or weren't CRA'd. And I thought there was certainly appetite for that, but I think at the end of the day, folks from the admin tweeted effusively in favor of them, right whenever they might have been on the cusp of being CRA'd, which is not to say it's bad or good. It's just to say, whenever one entity gets in power and they have something that gives them leverage, it's hard to sort of come off that. It's hard to sort of be Odysseus at the mast and saying, like, I'm going to tie my own hands and make things more difficult for myself so that I can't enforce the law. That was my impression, at least, of merger guidelines. I mean, they're largely identical to, they are identical to what was enacted under, or promulgated under Con. Even, despite the fact that there were originally dissents and like the original HSR rules were, understood to be unconstitutional by folks within FTC. So that's sort of the merger guideline point. With respect to consumer welfare, you brought that up, Judge Starr, or Brantley, sorry, it's first name basis. Joseph mentioned that Metter, I always say Metter, I don't actually know that that's correct, but Mark, he wants to keep the consumer welfare standard, I think is what you said. And I'd say like more in line with what Brantley was saying was, it seems to me that he's trying to re-envision it. He's trying to add to it. He's trying to sort of add further texture and color to what that might mean. So typically under a Borkian approach, we thought of consumer welfare as just price and output. So with Amazon, I might get my products at my door same day or next day for relatively cheap cost. And so what I think what Mark is inviting us to do is to think through other things like innovation and options and the source of the different intermediate businesses, et cetera. So I think, at the end of the day, without sort of keeping some semblance of consumer welfare, we just have like a sheer sort of Polanyian approach to antitrust law where like the government is literally just wielding its power to rein in big tech or big governments or big business. And so I think they need some semblance of a unifying principle, and that's what the consumer welfare standard gives them.
So maybe I'll go next. I was, I guess, surprised that there's no effort to change the merger guidelines from what the Biden administration did at the end of, their term. The genesis of the guidelines back in the late 1960s was an effort to provide clarity to potential targets of merger enforcement, because the antitrust laws and the merger law is fairly ambiguous. In theory, the government could go after almost any merger and justify the decision under the law, under the Clayton Act, and the guidelines constitute an effort to sort of clarify and provide notice to people and provide some sense that there's safe harbors, that there's some areas of enforcement where you didn't need to worry. You could actually go ahead and go ahead with your merger, and you don't have to worry about the government calling you up. And so what's a little troubling about this most recent revision of the guidelines was that in philosophically, the effort was to throw all of that out. It was to it was to make the guidelines less clear, to increase the amount of discretion to enforcers, and so have a lot of businesses unsure, unable to predict whether they're going to fall under the merger guidelines. And who does that hurt the most? It hurts smaller businesses more than larger businesses, because the larger businesses know they're going to fall under the guidelines, but the smaller businesses were the ones who were largely in safe harbors under the older guidelines. So two things happened with the guidelines revision, recent guidelines revision. The numerical thresholds were reduced to enable the enforcement to go after more, and broaden the enforcement net, and to present a picture of a lack of clarity to potential targets so they don't know. And the other thing was the increase in the reporting requirements. So and I think the DOJ and the FTC themselves reported that they think that the new reporting burden on the guidelines would cost 4 times as much as it did before the change. And so who's that going to hurt? It's going to hurt smaller businesses. The 4 times increase in cost is not going to be that big of a deal for Amazon, but it's going to be a big deal for the relatively smaller businesses. So I think in a philosophical sense, this change in the guidelines at the end of the Biden administration was very much against the initial goal, the initial purpose for the guidelines. Now, I think that I think Austin's right, that the Trump administration, I think they say, well, wait, this just frees our hands. This just gives us more options. Why would we revise the guidelines when now we have more options to enforce the law? So in that sense, maybe that might explain a motivation on their part to keep the guidelines without revising them. But I think it's a troubling decision. I think that there needs to be an effort to go back to the initial goal of the guidelines, which was to provide some clarity to potential targets of enforcement.
Anything else on guidelines and consumer welfare you want to add?
Very quickly, so I think Keith is right to highlight the thresholds. That's really the key, probably the most important part of the merger guidelines. And I would add also, they added a new presumption, basically saying if 2 firms have a 30% market share, that also can be anti-competitive. And I think what the guidelines represent is that this new structure-focused idea of antitrust, right? We care about how many competitors are in a market as opposed to just performance metrics, right? That is shared, I think, by folks like Mark. And, if you don't believe that, just look at his speech and you'll see the sentence, big is bad, right? So I think that view of antitrust is protecting, caring about deconcentration in and of itself has prevailed, at least in some factions of both sides of the aisle. But I would note there are differences, right? And I think the consumer welfare point is one of them. And I agree that unlike the Neo-Brandeisians, it's clear that Mark and others want to include ideas like flourishing and moral concerns into antitrust analysis. That's not something that you see with the Neo-Brandeisians. I mean, they're basically Marxists, right? They don't care much about flourishing and Aristotle and all of that. And the other difference I would point out, and I think is very important, and it's also about consumer welfare, is the Neo-Brandeisians wanted antitrust to be political, right? So if we're thinking about common law versus statute, they saw antitrust as public law to protect democracy. And I don't think that's necessarily true with Mark. I think he recognizes, or he believes, that there's a relationship between the antitrust laws and democracy. But I don't think he wants to politicize antitrust law in the same way that the Neo-Brandeisians did. And on those two latter things, I mean, people like me can agree with him. Yeah, we want to keep antitrust focused on private law, individual transactions. And yeah, I think we should not neglect concerns about order and morality, and we should abandon legal positivism, let's say. But on the big is bad point, that's not ultimately, I think, defensible, especially when you think about something like innovation, right? The idea that more deconcentration is always going to get you better market outcomes. That's not true when you're dealing with milk and regular products. It's definitely not true when you're thinking about dynamic Schumpeterian competition, right? Scale sometimes can be what drives innovation. So I would say, again, some good in that speech, but still some issues.
Okay, a couple of questions on the common law before we open it up. I know, so this one, Keith, is for you. We've talked a lot about the common law and your content so far, and I just want to give a touch of my visceral reaction when people say common law. I feel like as a federal judge, I'm supposed to cringe and run away when people say that, right? Because we all learned day one of CivPro, Erie Railroad versus Tompkins, there is no such thing as federal common law unless you get to day 2 of common law and talk about the Warren Court due process decisions, and then there's a whole lot of common law style things going on. But because of that, most of the judges I know well dread court cases that involve them making the big decisions, if that makes sense. And we aren't given the big decisions a lot. In criminal trials, we don't decide if someone's guilty or not. That's up to we the people to decide. It's the sovereign who's deciding that. we decide how long they go to jail for. And I don't know many federal judges who enjoy taking on that big decision. We make big decisions in the equitable cases, and there are different judges who have different reactions. Some judges, like the ones I know best, dread it. And if they get a new case with an injunction request, they say, oh, crud, this one's on me. It's not we the people who's deciding it. And some judges love it. And that's what we got on Friday from the Supreme Court. But I think all of us would agree that Sherman Act, like you summarized in one beautiful sentence, Keith, Sherman Act is this almost crisp codification of the common law. Is it delegating authority to FTC and DOJ antitrust? Is it delegating authority to us judges, or is it a mix? How am I supposed to look at that the next time I have another antitrust case come in? Am I supposed to dread it, or am I supposed to say, I'm not the only one with power here? DOJ, FTC also have power. How do I approach it?
Happy to give you advice then. The Sherman Act is, I said it can be boiled down to 5 words. Congress essentially kicked it over to courts to develop what those terms mean, and it's happened through many cases. And so, sure, if a judge were to ask me, how should I be viewing this statute, it is a common law. It is an invitation to the courts to develop a common law of antitrust, a federal common law of antitrust, which the courts have done. And so I think you're at your highest power under the Sherman Act. And one paradox of judging, of course, that a judge doesn't want to say openly, oh, I'm acting, in a common law fashion. A judge would want to say, well, I'm just following the law. But that's what the Sherman Act invites you to do. It invites you to think about, and because by the time a case reaches you, there are already so many uncertainties that the law doesn't tell you exactly what has to happen. So you have to make some decision, and that's an exercise of discretion. And so that discretion has to be informed by what you think, are the relevant trade-offs there. As far as the FTC goes, the FTC comes later. The Sherman Act is 1890. The FTC comes in 1914. And the FTC Act was an effort to carve some things out of the Sherman Act and put them in special courts. I would not call them kangaroo courts. That would be wrong to say that. But to take them out of the courts and put them under special processes that are different from the courts. That effort, I think, is slowly being unwound. I think that the current Supreme Court, under the originalist doctrine, is probably going to unwind all of that at some point, if it keeps going in this way. But that's where we are, and that's why I think a judge such as yourself should feel at the height of his power in terms of applying this common law process to the Sherman Act.
So yes, you can add, and then I'll ask a question after.
Just real quick, I mean, it's not just Keith and other scholars who are saying the Sherman Act's a common law statute. The Supreme Court has said that, right? I believe in the Legion case.
Yes.
So that's pretty good authority for any judge. And when it comes to why, if you think about the basic things we use to interpret statutes, and this is another part of Mark's speech, right? Getting back into an originalist approach. Why have we ignored originalism when it comes to antitrust? Again, there's a reason why we do that. As Keith mentioned, the text of the Sherman Act doesn't get you anywhere, right? It's very high level. I'm not going to say it's vague, but it's certainly not clear enough to enforce individual cases. Okay, what do we do next? Well, let's look at the statutory history, right? Well, there's a lot of concrete stuff there. The problem is there is a lot of it. It doesn't all cohere or fit together, right? We got to protect democracy. We want to have a healthy economy. We want to have fairness, right? It's not something that you can find one clear goal and say, okay, this is how we should enforce the law. And that's why precedent is so important, and also why reason, right? Common sense things like economics is so important when we enforce the law. And just finally, when it comes to the FTC, I mean, the 2010 merger guidelines that were withdrawn by the Biden administration, those were cited by courts a lot. They were treated as persuasive authority. They were very, very, very helpful and well regarded. I highly doubt that these new 2023 guidelines are going to be nearly as helpful. So I think the agencies do have a role in putting forward good guidance that courts can look at and say, oh, this is helpful. This is good persuasive authority I can rely on. But I just don't think we're seeing that with the current merger guidelines at all, nor will we, frankly.
Okay, and my last question on the common law before we open it up to questions from the audience, and this is, I guess, two statements, one that you made, Austin, one that you made, Joseph, that I think match up or merge, to borrow a relevant term, fairly well. One, Austin, you said that the common law doesn't cover everything. We do have gaps. And then, Joseph, you talked about that when we're looking at big firm censorship, it seems to be an odd fit with current antitrust laws. Right, under Sherman Section 1, we're looking for that agreement between two firms to be anti-competitive, and you haven't seen evidence of the agreement between two firms. And then Section 2 requires some sort of merger that if they're not contemplating it. So we've got some gaps. You've noticed that there are gaps. I guess my question is, are we going to see an experiment at the end of the Trump 2 administration where we say, aha, we need to open up Section 230 or come up with some new other law that Austin has yet to draft, or maybe you have drafted it, but it's not been introduced yet, to where we should be looking at censorship through a lens other than antitrust?
So I can neither confirm nor deny that, no, but yeah, I mean, this is an example of why I think Professor Hylton is correct in sort of praising the common law and addressing and contributing to economic liberty and human flourishing. Section 230 is this obviously massive hurdle to people suing tech companies. If, you know, in any other realm of the economy, if you are harmed, you know, there's either a regulatory body that oversees and sort of creates guidelines and promulgates rules that protect you, or the doors of the court are open to you to seek redress. In the sort of digital space, there isn't that meaningful of an option depending on what your harm is, and that's because of Section 230. And so, you know, query whether or not this is a good development or a bad development, but courts have started to sort of squint at Section 230 and sort of interpret it in these tortured ways in order to open up the courtroom doors to people, allow plaintiffs to survive motions to dismiss, et cetera. And so I don't know how responsive that was to your question, but all that's to say is I think the common law actually is sort of quite nimble in being able to, you know, address some of the concerns that we're describing. In terms of filling the gaps of the common law, I think that Congress can do low-hanging fruit. So Robinson-Patman Act has basically been read out of the law. That's because it's notoriously difficult for juries to understand. It's notoriously difficult for judges to understand and apply. And so I think Congress can do certain things like, you know, a lot of grocers have issues that are in the vein of the Robinson-Patman Act. And you might be able to sort of craft legislation that narrowly targets these discrete issues as they come up. So I see it as very much so, like, I think the broad sort of common law approach we've laid out is good, and then Congress sort of plugs in holes as they arise. Yeah.
Any further thoughts on antitrust and censoring than what you've
Sure.
already given us, Joseph?
Just real quick. So I think there's a consensus on two things on the right. First of all, the antitrust laws themselves really don't provide a lot of recourse for censorship. But I also think there's a consensus that they sure can be a way to show it to the tech companies that we think are censoring us. Those things are both widely held. But on that latter point, I think that's an assumption that should be examined more by conservatives. So when you think about things like breakups, right, which are very much on the table in the Meta case, FTC v. Meta, and also in Google, you know, the idea that the censorship concerns are going to get any better just because Google has to divest Chrome or Facebook has to divest Instagram, I think that's speculation at best. Now, the other thing I would say with respect to 230 and the idea of just breakups and disrupting the network effects and the network economies that make these platforms work, I don't know, and I've said this before, I sometimes hear crickets, but if I was a conservative concerned about getting my voice out there and having a media that was more diverse, I'd be a lot happier now after decades of the social media platform internet revolution than I would be, you know, 30 years ago when you had large, basically 6 New York media conglomerates, right, that had most of the media properties, right? So I think conservatives should recognize that the social media, the platform economics, the internet world has, I think, been better off and made them better off in diversifying the media landscape and allowing other views to get out there, even if you believe that censorship still does occur in some cases.
Can I just add one thing to this? So I haven't given a lot of thought to the censorship and antitrust issue, but as I said, the statute is fairly flexible. Historically, antitrust has been considered a matter of price and output, just those things. But what is censorship? I mean, censorship is an abuse of consumers. And what allows you to abuse consumers? Well, monopoly power allows you to abuse consumers. So certainly the censorship issue is related to antitrust. And so, you know, just thinking about it, I wouldn't think that the two topics are completely unrelated, or that it's impossible to craft an antitrust claim that's based on the censorship practices of various tech businesses.
Okay, enough of my questions of the panel. I would love to hear from we the people. So if you have a question in the audience that you want to ask our fine panelists, then grab a mic or walk to a mic.
All right, so, ooh, that's loud. So this is primarily directed to Professor Hylton, but if the other members of the panel would like to join in, please do. So you brought up universities and their unique, I think you called it a distinct court system that they use to resolve kind of disputes in-house. One of the things that does make the university resolution of disputes, I would say fundamentally un-American, is that they're allowed to have an inquisitional system and not an adversarial one, so that the accused doesn't have the right to cross-examine the accuser. This is especially true when you have a male student accused of rape by a female student. And I'm just wondering, have you given any thought to the pros and cons in a more general way of adversarial systems to inquisitional ones in the criminal process?
The answer to that is yes. First, it's my impression that the kinds of systems that we have in universities actually varies quite a bit, that some universities have inquisitorial systems, some have closer to a system that allows for cross-examination. I think it depends. I think there's some variation. I think my own reading of the law, I mentioned Harvard versus SFFA that said that, okay, if you're getting money from the government, then Title VI of the Civil Rights Act applies, and so processes that appear to be discriminatory are now, the government can, you know, can in a sense regulate those, even though you're a private university getting money from the government. And the court said it's actually the Equal Protection Clause that's applying to universities that collect government money. And I think it's a short step from that conclusion to say, well, the Due Process Clause ought to apply as well. And if the Due Process Clause applies, then a lot of these inquisitorial systems in universities actually violate Harvard versus SFFA already. I think there are, and I think it's a short step before we get to that conclusion, if we're not there already. So my own belief is that the inquisitorial systems that remain in some universities are illegal right now, but they remain in effect in many universities. I think that, again, I cite this largely because when you get away from the court processes that have developed over time and you go into these private systems, you can get the kind of system that you just described, where you know, accused parties don't have rights, where administrators kind of make decisions about what's going to happen, you know, often based on their own conceptions about what the best approach is.
So if the states are laboratories of democracies, Keith, then universities are laboratories of, I'm joking, you don't have to fill in the blank.
They're laboratories.
That's fun.
So more generally, though, if you had to argue that inquisitorial systems are generally not as good because they're less just, and you were to argue against the continental European way of resolving similar disputes? What would you say?
Well, I think it's important. First of all, I think many lawyers have said that cross-examination is the key to truth, and I guess I'm inclined to believe that statement. But more importantly, the adversarial system allows for different arguments to come out and gives everyone an incentive to bring those different arguments to the court, and puts the judge in a position of hearing those different arguments and trying to make some resolution between those arguments. I think that's a better system. I think that's a system that, and of course, a lot depends on how the system is run. Sometimes a preponderance standard is appropriate. Sometimes a reasonable doubt standard is appropriate, depending on the nature of the punishments, the nature of the issues. But I think the adversarial system has a lot in going in favor of it, and I would offer as an example the difference between competition law enforcement in America versus the European Union. And if you talk to lawyers who have been involved in competition law cases in the European Union, they'll tell you, look, there are a lot of procedural issues that are troubling in the European Union system that we think we've solved a long time ago in the U.S.
Next question.
Good afternoon. My name is Jason Milch. I'm a recent graduate of the University of Pennsylvania, so I very much appreciated Professor Hylton's comments from earlier. And my question is related to what you talked about towards the end, which is Erie v. Tompkins. In the past couple of years, there's been a resurgence of interest in general law in response to Erie, and I'm curious to ask the panel whether you think Erie is on its way out, and if so, how will the federal courts live in a post-Erie federal common law world, given the fact that there is such a large array of contradictory ideologies within the federal judiciary?
Well, I mean, they lived in that world before Erie, so they can live in that world again. Though my views are somewhat limited. I guess my argument was just, look, the Sherman Antitrust Law is a federal statute, and it invites federal courts to develop this common law of antitrust. And I think what's unique about the statute is how sparse it is. On the other hand, I think every federal statute that limits jurisdiction to federal courts, even the complicated ones, in a sense, does invite federal courts to fill in the gaps through the common law process. I'm a little reluctant to go further than that and to say, Erie v. Tompkins needs to go out of the window. I don't want to offer an opinion on that, and I'm stopping short of that position.
Next question.
Thanks. This question is largely directed at Mr. Rogers. So you said that a standard is still necessary for antitrust law, and that Mark Meador, I hope I'm pronouncing his name right, embraces a version of the consumer welfare standard. And in his essay, which you referenced, Antitrust Policy for the Conservative, Meador himself redefines consumer welfare as trading partner surplus. And I was wondering, because it seemed like you were alluding that his definition of consumer welfare still includes welfare-enhancing activities that we want firms to engage in, like innovation. But trading partner surplus does not obviously comprise that to me, and I'm wondering if you think it does, or if I misread his essay.
I think, it's been a few weeks since I've revisited his essay, but, my understanding of what he was trying to say is that if you take the sort of technocratic approach of, just examining price, outputs, using, frankly, contested principles of economics to try to resolve, endlessly complex issues, I think, from a Schumpeterian perspective, if nothing else, we know that the economy is very difficult to understand and conceptualize, et cetera. It's complex. And so he, I think, is trying to get at, it's not a matter of like what's the most quote unquote efficient perspective from like a Coasian perspective where you just have net sort of gains, like regardless of whether we're looking at a consumer or a seller, a buyer, et cetera. And he wants to put the focus on the consumer surplus. So how is this affecting the consumer? How is this affecting buyers? How is this affecting people whenever they receive services? I'm not sure if that adequately sort of addresses your question, but I think what he's trying to get away from is this sort of Chicago school approach to antitrust law that, thinks that you can put things in a test tube and swirl them around and just look at them and come up with the right economic solution. He's trying to say, like, no, let's look at how this is impacting consumers.
I'll just make one point on that, if I might. With respect to the trading partner welfare standard that is put forward in that speech, and you've seen that in other places as well, Gail Slater, the head of the DOJ, also gave a similar speech, and she talked about antitrust protecting workers and consumers and all a variety of things. It's important to remember there can be trade-offs, right, that don't exist when you're looking narrowly at, let's say, consumers. So take the example of, let's say, a buyer group, right? Now, buyer cartels are anti-competitive, and they're going to harm the sellers, but they're also going to harm consumers because they restrict output. But a lot of times, buying groups can create leverage that increases output. Now, sellers, trading partners, right, they're going to be harmed by that. They're going to lose surplus. But consumers could be better off, right, from the lower prices that could be passed on. So that happens with labor all the time, too, and a big thing in mergers, right? Used to be, you could go to the agencies and say, well, we're going to save some HR efficiencies here, and that's going to help us lower prices for consumers. Well, that's another great case where labor, a group that we're told, should matter for antitrust, could be harmed, but consumers would be better off. So those are very real, serious trade-offs, and there's a long line of economic literature that says that those sorts of comparisons between different groups and how we weigh things, that could really add a lot of complexity and make it antitrust a lot less administrable once you start to get into those sorts of trade-offs.
Okay, so no further questions. Let me ask the panelists if you want to have any parting final thoughts. You need to get back to the Hill.
I probably should get back to the Hill. I don't know that I have necessarily anything further to add. I mean, what I will say is certainly appreciate the panel discussion, appreciate getting invited. I will just kind of note that, fascinating topic, but these are very broad and capacious terms. They're very contested terms. I think at the end of the day, what constitutes economic liberty, what constitutes human flourishing, what constitutes the common law even, might be in dispute. It's important that we have sort of, A, a shared vision of what these things mean, but B, we can do law all day. We can sort of come up with different ways of regulating or taking a common law approach, whatever. At the end of the day, if it's not contributing to human flourishing, query whether what we're doing is productive or fruitful. So, for my part, I think I would align with Joseph in saying, I kind of take an Aristotelian approach to human flourishing. I very much so resonate with his idea of eudaimonia, and I think that's sadly and unfortunately interpreted as happiness in English, but some sense of what it means to live into one's end as a human and to sort of, as Irenaeus put it, sort of man fully alive. Like, how can humans excel? And so, we can talk all day about the extent to which the government should be involved, this and that, but at the end of the day, if humans aren't excelling in virtue and becoming good and the sort of best versions of themselves, I think we're sort of remiss. So,
I guess I'll pick up next and let Joseph have the last word. So Austin is right. The topics that we're dealing with are rather broad topics, and human flourishing is a pretty ambiguous term. I will admit I am a utilitarian, and I'm on print saying that I'm a utilitarian. So the term human flourishing from a utilitarian perspective, raises questions. Well, what does that mean? Well, it must mean the same thing as, maximizing society's welfare. Though obviously a follower of Aristotle would not take that view. Economic liberty, even that's a fairly open term for interpretation. You know, what is economic liberty? Well, we think it means freedom to do whatever you want to in economics, but it doesn't mean doing illegal things that are, economically profitable. So we'd have to qualify the term economic liberty. The one term that I guess I feel I have a good sense of what it means is the common law. I think I have a sense of what the common law process is. And I think to the extent we were asking, well, what's the connection between the common law and someone's conception of human flourishing and economic liberty? Well, I think there's a strong connection. And I think that we've got a bunch of experiments that have been run out throughout the world over time. And the experiments keep coming out in favor of the common law process. You know, I mentioned just a few minutes ago the difference between European antitrust law and American antitrust law. And most of the practitioners will tell you that American antitrust law is better in terms of substance and procedure than what they run into in the European system. So again, I think that's just one example of many in which the common law process appears to win on these questions of human flourishing and economic liberty compared to other systems and approaches.
Okay, so let me just say, putting this in political context here, I think you've got four options. So we've talked a lot about the debate on the right. People that believe order and flourishing is important, but are not necessarily as keen on economic liberty. You've got another group of people that care about ordered liberty. So we want to bring order back into our political economy. We think that's important, but we don't think it should come at the expense of economic liberty. Count me in that camp. You've got maybe sort of a center-left group that will say, you know, maybe a little bit like Keith, you know, we like economic liberty, but we're not as keen on bringing on the flourishing and all that moralistic language into our political economy. And then, of course, you've got the progressive left, the neo-Brandeisians, who don't really care about order or liberty, frankly. And what I would like to say in defense of the ordered liberty approach is I think we do have good evidence in support of economic liberty. If you look at the United States and the tremendous economy we have relative to the rest of the world from deregulation and the innovation that we have, that's a good thing. And we don't want to throw the baby out with the bathwater just because it's true, right? And Schumpeter predicted this. Schumpeter said, capitalism is great. It's going to give you all these wonders. It's going to be great for the economy, but it's going to come at a moral cost, right? And he's right about that. So I think the point is, yes, economic liberty is good, but there are these moral costs that have happened as a result of neoliberalism and capitalism, and we've got to focus on bringing back order. Now, what order means, that's a really big question. And again, I think you have three views, right? You can take a more modern approach, natural rights, Locke, Hobbes, Rousseau, that type of view. You can take a more classical approach, like Aristotle. You know, I think Gail Slater quoted Thomas Aquinas in her speech, right? That sort of view. And I would just offer a third, the Schumpeterian view, which is a bit different from either, getting at even more of a pre-Socratic sense of morality, a Homeric, almost heroic sense of entrepreneurialism. And I think that's important, and it also shows why the common law, I think, is so important at preserving that, precisely because it is about getting into those, as Blackstone said, those deeper ancient traditions that really, I think, are core to our society. So thanks very much.
All right, if you would, join me in thanking our panel.
Yes, thank you, Judge Starr, for guiding a great conversation. I think it was philosophical, practical, timely, and very edifying, so congratulations to you all. For all of us, we'll take almost a 15-minute break, and we'll start with the fourth panel at 3:45.